I was trying in the past to define a sort of general doctrine that I defined of a double limit. I mean, an enforceable document can't be more enforceable abroad than in the country of origin, and can't be more enforceable in the country of destination of the same local national enforceable documents. So well, it was just an experiment I have not defined enough, maybe. And so, again, in other words, does an authentic instrument issued in a member state produce all its effects in the entire European legal area, even if in the country of destination these effects are not attributed to national authentic instruments? Strange enough, would be. Does it mean that with the enforceable authentic instrument, it is possible to put under seizure, for instance, or auction off directly an asset of the debtor? That a provisional or protective measure can be obtained? See, for instance, Article 40 of Brussels 1A regulation in relation to Article 58, paragraph 1, last sentence. Article 40 is about protective measures that can be taken with a court decision, but Article 58, related to authentic instrument, states that an enforceable, let's say, authentic instrument shall carry with it, by operation of law, the power to proceed to any protective measures which exist under the law of the member state addressed, which is an extremely strong possibility, hard maybe sometimes. And then for us practitioners, notaries of the different European countries, what about registration? In certain legal systems, enforceability may also mean the quality permitting to register an authentic instrument in a public register, in a land register, for instance, or a commercial register. And in these cases, the authentic instrument, enforceable in the state of origin, should be able to produce the same effects in the state of destination. Better said, in order to get provisional and protective measure, for instance, in the state of destination, the authentic instrument must be able to entail the same effects also in its country of origin. A similar problem, similar concerns have also arisen with regard to the probative value of authentic instruments, as now regulated in Article 59 of succession regulation and Article 58 of matrimonial property regimes and property consequences for registered partnerships. As pointed out in the study carried out for the European Parliament in 2016, coordinated by Professor Paul Beaumont, the same Jonathan Fitchen and Jane Halliday, and published under the title "The Evidentiary Effects of the Authentic Acts in the Member States of the European Union in the Context of Successions." Also in this case, in case of a probative value, I mean, the problem becomes that of being able to know for each authentic instrument in question what exactly is, according to the rules of the state of origin, its probative value, to use also abroad. What can be proved by each authentic instrument? Normally, the factual elements recorded in the authentic instruments by the authority concerned, such as the date, the fact that the parties appeared before the authority at the date indicated, and they made certain declarations. And then again, the powers of the authority drawing up the instrument and the procedure under which the instrument is drawn up, the acts performed by the authority. These are the normal facts that you can prove with an authentic instrument almost in the entire Europe. And what about the content of the authentic instrument? This could be, for instance, the agreement between the parties, or the declarations of intent, the legal relationship could be the determination of the acts of the spouses, for instance, in matrimonial property regime, the law applicable to their matrimonial property regime, their respective shares, or any other element established under the law applicable. Of course, in principles, these are the elements that are certified in the authentic instrument with a privileged probative value, but in the wide variety of possible authentic instruments in the entire European Union, it will be necessary to check it case by case. And precisely for this purpose, the Council of Notaries of the European Union, the CNEV, has created a working group to collect data on authentic instruments, not only the notarial ones, in the different member states where the notarial function exists, in order to try to classify their probative effects. And the work has proved to be quite complex. And for that reason, I say we are not yet arrived to a possible, plausible, acceptable solution. And this was due mainly for the difficulty of finding a common language, even if among the notaries themselves, in relation with the concepts and rules existing from one country to another. Once again, I insist as a message for our seminar today in front of so many professionals of different kinds, and say that our challenge is to find a common language, a common understanding of the text and concepts, avoiding the mistake very frequent and very, very sorry about it, avoiding the mistake to bring even new things back to known and more familiar patterns, national rules, national laws, national practices. So please, without waiting for a pilot cases to end up before the national courts or in front of the European Court of Justice, let's examine ourselves the cases that surely happen to us in our daily practice. Let's spread the knowledge of the cases occurred and make them emerge as best practices for the professional and scientific community. And we hope that we can do it, we can start to do it even tomorrow in our round table. And just to end up, the subject is undoubtedly interesting and will certainly have to be studied in depth, also due to the obvious practical implications that it may have. And so thank you very much for your kind attention.